My apologies. And then on page 2 of that bench book, number 8 states that the plaintiff has brought the action against the defendant.
Okay.
And that'd be under section 41B 200 of the Midlands Revised Statuses. And this is also known as the Slayer status. This provision states that a person who is a culpable actor in the death of another individual may not inherit any of the money or property from the decedent.
Understood.
Additionally, under the stipulation tab, we'll draw your attention to stipulation 27.
Okay.
States that the Australian Federal Police took photographs and collected forensic evidence and other pieces of evidence during its investigation. However, through no fault of either party, all collected forensic evidence was destroyed during an explosion at the crime lab before any of it could be tested. In that same explosion, most of the photographs taken and pieces of physical evidence collected by the police were destroyed. I'd also like to direct your attention to stipulation 25.
Okay.
Which states simply that at the time of his death, Avery Bancroft's estate was worth approximately 404 million United States dollars. Now, turning your attention to the complaint tab under the factual background section.
Is that in the beginning or in the end of these?
It should be towards the beginning, correct? Are you organized? Beginning.
First page.
This one? Awesome.
I direct your attention to number 11, which states, on July 16th, 2015, the decedent executed a will naming the defendant as the beneficiary of 95% of the decedent's estate.
Okay.
Lastly, we'd like to now invoke Rule 603 and 615, which are the constructive swearing in and sequestration of all witnesses, barring party representatives. The plaintiff party representative in today's case is Shannon Shahid.
Okay. And I understand that there's experts in this case. Will they also be sequestered?
Yes, Your Honor.
Okay.
Now, on a final note, it'll be about preferences regarding moving around the well and approaching opposing counsel's witnesses in the bench. Starting with, should we ask permission to move and approach or do so freely?
Always ask permission to approach the bench and approach the witness, but you're free to move around the well however you like.
Yes, Your Honor. We I'll also like to ask your preferences about objection. Should we assume they're, when sustained, should we assume them stricken or move to strike them?
Move to strike always.
And with that, Your Honor, the plaintiff's side is ready to proceed with opening statements.
Okay. Before then, does the defense have any housekeeping they would like to address?
Yes, Your Honor. First, we would like to tender a character evidence form to the bench. This is a notice of intent to provide character evidence pursuant to Midland's Rules of Evidence 608A, which simply states that the credibility and truthfulness of witnesses may be attacked or questioned, and the defense intends to do so towards all of the plaintiff's witnesses in today's case. Additionally, if I could draw your attention to stipulation 6 in the bench book in front of you.
Okay.
This lists all of the pre-admitted exhibits in today's case that have been previously agreed upon by both the defense and plaintiff. And my co-counsel will also be tendering Exhibit 37. Permission for my co-counsel to approach and tender Exhibit 37 and the aforementioned character evidence form.
Yes. Has this been discussed with plaintiff's counsel?
They have signed the form and the pre-admitted exhibits have been agreed upon.
Okay.
Lastly, if I could direct your attention to stipulation 26. This lists several of the exhibits were found in Avery Bancroft's cabin following his passing by the Australian Federal Police, including Exhibit 37 that you have before you. And with that, the defense is ready to proceed.
Okay. I just asked that if you are admitting evidence, and this goes for both sides, you just make a note of it since there's a lot that has already been pre-admitted. So just make sure, you bring it in and say, per stipulation, whatever, it's been pre-admitted.
Yes, Your
I'm aware of it. Okay. And with that being said, plaintiff, if you're ready to begin your
Yes, Your
opening
Honor.
statement.
Yes, Your Honor. Your Honor, opposing counsel, and ladies and gentlemen of the jury, may it please the court. Taylor Hobson took his father's fortune against his will. We're all here today because of a will. In 2015, Avery Bancroft, a multi-millionaire in Midlands, finalized his will. This document originally divided Mr. Bancroft's $404 million estate between two parties. 5% of this will was supposed to go to Mr. Bancroft's youngest child, Shannon Shahid, while the other 95% of this inheritance was supposed to go to today's defendant, Taylor Hobson. But, ladies and gentlemen, this will change. In February of 2024, Mr. Bancroft expressed a desire to write the defendant out of his will entirely. Then, on April 22nd, both the defendant and Mr. Bancroft separately boarded the Mid-Riverina Express, a luxury train ride that departed from Sydney, Australia, and was headed to Perth. It was on this train ride that the defendant learned that they would be written out of their father's inheritance. It was at this point that a new will had emerged, but not one of paper. It was the will of Taylor Hobson to poison their father after they realized they wouldn't receive a penny of the inheritance they were desperately reliant upon. For years, Taylor Hobson had been receiving a monthly stipend of $50,000 from her father. The defendant saved none of this money, and this wasn't a problem until suddenly, in April of 2023, when these payments stopped. The defendant was terrified. She had no money, no job, no income of her own, and no way to finance the lifestyle she had been enjoying for 13 years. Today, the defendant's half-brother, Shannon Shahid, has brought forward this case under a provision of Midland's law known as the Slayer Statute. Under this provision, any individual found to be a culpable actor in the death of another is barred from receiving any portion of the decedent's estate. Throughout the course of today's trial, we will prove that the defendant was a culpable actor in the death of their father. And we will prove this to you by showing that the defendant purposefully caused the death of their father. When one acts with the expectation that these actions will cause a certain result, they act purposefully. We, the plaintiff, have the responsibility to prove this by a preponderance of the evidence, meaning more likely than not. And we will meet our burden by calling forth 3 witnesses. First, you will hear that the defendant had the financial motive to commit this crime. You will hear from Kirby Doolittle, Mr. Bancroft's former personal assistant. Ms. Doolittle will corroborate not only that Mr. Bancroft planned to change his will, but that the defendant knew that these changes would be made. Next, you will hear that the defendant had the means to poison their father. You will hear from Dr. Hillary Edmond, a board-certified physician in pulmonary medicine, that Mr. Bancroft had chronic kidney disease. Dr. Edmond will tell you that the defendant knew that if Mr. Bancroft ingested too much potassium, he would die. Dr. Edmond will explain that Mr. Bancroft suffered cardiac arrest due to the ingestion of a potassium-rich substance like banana extract. Finally, you will hear that the defendant took advantage of an opportunity. Jordan Nathanson, a private investigator aboard the Mid-Riverina, will testify that Taylor Hobson purchased banana extract, which they used to poison their father. Taylor Hobson is not the grieving son the defense will try and paint him as today. We, the plaintiff, will prove that the defendant poisoned their father and made a killing from his inheritance. An inheritance, ladies and gentlemen, they were not supposed to receive, but the defendant got their father's money anyway. They got their father's money against his will when they poisoned him with banana extract. At the end of today's trial, my co-counsel, Alice Wang, will come before you and ask that you consider all that you've seen to come to the only reasonable conclusion, to make sure that someone who had a hand in the death of their father does not reap the benefits of that crime. She will ask that you find Taylor Hobson liable. Thank you.
Defense, whenever you're ready.
Yes, Your Honor. Permission to construct a demonstrative, Your Honor?
Yes, you may.
Can I begin?
You may.
Only one person was willing to kill for a confession. Members of the jury, it's true that on April 25th, 2024, Mr. Bancroft died while aboard the Mid-Riverina Express. We agree that he was intentionally poisoned with potassium, and it's undeniable that the perpetrator had an unnerving resentment for Mr. Bancroft. But what the plaintiff got wrong is the question of who. The plaintiff fails to acknowledge all of the evidence. They fail to acknowledge that another individual on that train had the same exact means as Mr. Hobson, the same exact opportunity, and an even stronger motive to kill. That's because they started in the middle. So I want to take you back to the beginning, about 2 years ago. In the center of Midlands stood a business, the Black Bear Casino. The casino was owned by Mr. Avery Bancroft. But in December of 2022, that casino burned to the ground. It was a tragedy. 18 people died, including 13 patrons and 5 brave firefighters. The Midlands community lost friends, coworkers, and family that day. And the Midlands community suspected foul play on the part of Mr. Bancroft, and they wanted a confession. Well, on the morning of April 25th, 2024, next to Mr. Bancroft's dead body, the Australian police found a note. A note demanding just that, a confession. Confess or burn. Members of the jury, this note has been in front of you since the start of trial, and the plaintiff has already failed to acknowledge it. Because only one person made this note, and only one person was willing to kill for a confession. That person is Kelly Dews. Kelly was a firefighter who fought at the casino fire. Kelly lost friends in the fire. They almost died in the fire, and Kelly boarded the Mid-Riverina Express with one thing in mind. Kelly had every reason to hate Mr. Bancroft, every reason to want justice, and every reason to kill for a confession. You know who didn't? Mr. Hobson. And he's going to tell you that today. While his relationship with his father wasn't perfect, there was nothing to confess. What you'll hear is that Kelly was suspicious throughout his time on the train, stuffing mysterious supplements in her medicine bag, acting hostile towards Mr. Bancroft, and seen trying to take this note from the scene of the crime. Unfortunately for Mr. Hobson, it wasn't until the day of his father's funeral that he would come to suspect the sinister truth. That Kelly was willing to kill for a confession. And she did. But Mr. Hobson wasn't the only one on the train who saw Kelly's suspicious behavior. A photojournalist is going to tell you that throughout her time on the train, she saw Kelly lurking around Mr. Bancroft's cabin alone. She's also going to tell you that every time she asked Kelly about the casino fire, she would clam up and avoid it at all costs. And today we're also going to bring you an expert. Now, the doctor is going to tell you that there are traits of an intentional killer. He conducted 3 separate tests on Mr. Hobson looking for those traits. He found none. But the doctor is also going to tell you that he treated firefighters like Kelly after the casino fire. And what he saw was that they were often left with feelings of depression and resentment that could last a lifetime and force firefighters like Kelly to do otherwise unspeakable things. Members of the jury, as I tell you all of this today, I want to remind you of something very important. We as the defense don't have a burden to prove, but the plaintiff does. The plaintiff has to prove their case by a preponderance of the evidence. They have to tell you that their story is more likely than every other explanation there is for Mr. Bancroft's death. And if they're successful, Mr. Hobson will be ineligible to inherit any of his father's estate. But they won't be able to do that today. Instead, they're going to confuse Mr. Hobson's proximity to the evidence as proof he killed his father. But that's not enough. So I want you to keep one question in mind throughout the entirety of trial. What confession was Taylor Hobson after? In about 3 hours, my co-counsel, Mo Chabe, is going to come before you, and he's going to ask you that question again. And when the plaintiff leaves you answerless, you'll come to accept that only Kelly was willing to kill for a confession. And the defense will ask you to find a verdict of not liable. Thank you.
Whenever you're ready, you can call your first witness.
Yes, Your Honor, the plaintiff calls Ms. Kirby Doolittle to the stand. Permission to set up for the motions.
Granted.
Point of order, Your Honor, may I move as necessary to see the motion?
Of course.
Can we proceed?
Just let her get set it up so she can watch as well.
Yes, Your Honor.
Can you see from there?
I can. Yes, thank
You
you.
may come here.
Good afternoon. Please state your name for the court.
Hi, my name is Kirby Doolittle.
And why are you here today, Ms. Doolittle?
I'm here in court today because I was Avery Bancroft's personal assistant. I worked with him up until his death on the Mid-Laguna Express.
How did you become Mr. Bancroft's personal assistant?
Well, it wasn't the usual route, you know. I was actually kind of in between jobs at the time. I'm 5 younger siblings. My parents really aren't around, so it's my job to try and take care of them, the matron of the family, some could say. At the time, I was working as security guard at this gala. I heard Avery saying that his assistant just up and put on him, so you know what? I thought I'd take a chance. Went up to him, I told him I would be the best personal assistant you ever had, and he hired me.
What were your responsibilities as his assistant?
I did just about anything Avery needed. You know, he was a very busy man. I organized his emails, I wrote transcripts for his voice memos, I got his coffee. Avery gave me something in my life that I was lacking for a while, you know, the structures and sense of security finally.
So, why were you and Mr. Bancroft on the Mid-Riverina Express in April of 2024?
Avery informed me that he wanted to explore the western side of Australia, so I booked the tickets around February 1st. I was a little hesitant about leaving my family, but Avery reassured me that as long as I'm an employee of Bancroft Estates, my family will be well taken care of.
And can you give the jury a brief description of how that trip was supposed to go?
Yeah. We were to board on April 22nd. Over the trip, we would stop on, I think, 3 excursions, and then we would arrive in Perth on April 25th.
So, how did that trip actually begin for you?
We checked in around 5 p.m. and then I ran into Taylor Hobson.
Did you know that the defendant was going to be on the train?
No, I wasn't aware of Taylor's, being on the train at all. I was actually quite surprised.
Why were you surprised?
Taylor and their father did not have the best relationship at all. You know, I was constantly hearing them arguing on the phone.
Did you ever hear what they would argue about?
Taylor would constantly argue with Avery about his will.
Now, you mentioned voice memos. Did Mr. Bancroft make any voice memos on the train?
Yes, Avery loved voice memos. He made, I believe, 3 of them on the train, and I type of transcripts of them. It was a regular part of my job.
Would you be familiar with those voice memos if I showed them to you today?
I would.
Permission to approach opposing counsel to the bench?
Yes.
And counsel, what is this?
This is exhibits 29A through D. Let the record reflect, I'm now approaching opposing counsel. And Ms. Doolittle in turn. It has been pre-marked as exhibits 29A through Z. Would Your Honor like a courtesy copy?
Yes, please, congratulations.
Ms. Doolittle, what did I hand you?
You handed me 29A through C, and 29B is going to be a declaration of me saying that everything is very accurate.
Do these voice memos look to be fair and accurate?
They appear to be so.
Have they been changed or altered in any way?
No.
Your Honor, at this time, plaintiff moves to enter exhibits 29A through C into evidence.
Any objection by the defense?
Yes, Your Honor. An objection to hearsay within hearsay?
Specifically to all of them, or is there one specific?
To all of them, Your Honor.
Okay, response?
Yes, Your Honor, the entirety of these voice memos is an exception to hearsay under Rule 8036. Under Rule 8036, records of a regularly conducted business activity are an exception to hearsay. You heard Ms. Doolittle testify that as part of her regular conduct at her job, she generated transcripts of the voice memos that her boss, Avery Bancroft, would record, and that therefore falls under this exception to hearsay.
May I respond?
Yes.
Yes. The 8036 exception only applies to the transcription. It does not apply to any of the contents within the memos, and therefore this is still hearsay within hearsay.
May I respond?
Yes.
Nowhere within the rule of 8036 does it say that anything about how just a transcription is excluded from the hearsay rule. 8036 states that any record of a regularly conducted business activity is in full excluded from hearsay. It was part of Ms. Doolittle's job to type up these transcripts, and therefore they are exceptions to hearsay.
My question, Counselor, is these transcripts,
Yes, Your Honor.
these are transcripts that she is writing them down as she's interpreting these voice memos, correct?
Transcribing, essentially, yes.
But she's doing it as whatever she's interpreting.
I believe so, Your Honor.
I'll let you have the last word.
Yes, Your Honor. The record, as 8036 refers to a record of regularly conducted activity, is the transcription. The contents of each voice memo, because it varies from memo to memo, is not regularly conducted, and therefore only the transcription falls under this exception.
Your Honor.
I'm gonna allow it in.
Yes, Your Honor.
Yes, Your Honor.
But if you feel that it goes beyond, feel free to make the objection again.
Yes, Your Honor.
Just to clarify, Your Honor, this is entered into evidence?
Yes, specifically 29A through C, correct?
Yes, Your Honor. Now, Ms. Doolittle, I'd like to start with the first voice memo that Avery Bancroft recorded on April 23rd at 6:16 a.m. Could you tell the jury what the first three sentences of this voice memo say?
Kirby compiled a list of how much of my money Taylor has wasted over the years. Apparently, cutting Taylor off wasn't enough. So I want a full accounting before I take drastic action next month.
Ms. Doolittle, do you know what Mr. Bancroft meant about cutting Taylor off?
Avery was giving Taylor a monthly allowance.
And would you be familiar with a copy of Mr. Bancroft's bank statements if I showed them to you today?
I will.
Permission to approach?
You may.
Let the record reflect on approaching opposing counsel. And Ms. Doolittle in return, so this has been pre-marked as Exhibit 22. John, first
Yes.
copy. Ms. Doolittle, what did I hand you?
This is Avery's bank statements beginning May 1st of 2022 through April 30th of 2024.
Do they look to be fair and accurate?
It appears to be so.
Have they been changed or altered in any way?
No.
Your Honor, at this time, plaintiff moves to enter Exhibit 22 into evidence. Pursuant to Stipulation 7, all hearsay objections have been waived to this exhibit.
Do you have any other objections on any other grounds, defense?
No, Your Honor.
Okay, it is so entered.
Yes, Your Honor. Now, Ms. Doolittle, if you could turn to the second page of those bank statements. Could you tell the jury how large of a monthly allowance that Mr. Bancroft was sending to the defendant?
It is $50,000.
And when did Mr. Bancroft stop sending these monthly $50,000 payments?
Just around April of 2023.
Can you put that sign out? Now, we talked about that second sentence of the first voice memo. But you also mentioned that Mr. Bancroft asked you to compile a list of how much money Taylor had wasted. Did you tell anyone else on the train that Mr. Bancroft had instructed you to do this?
That same night when I was doing my job, Taylor found me. She asked me what I was doing. I informed him that I was doing the accounting that his father asked me to
Objection,
do.
Your Honor,
Yes.
to hearsay to the statements of Cody Brewer.
Specifically, what statement were you trying to elicit?
Yes, Your Honor, Ms. Doolittle was testifying that after Taylor Hobson asked her what she was doing, Ms. Doolittle responded that she was conducting this financial audit that Mr. Bancroft had instructed her to do.
Okay. And she's testifying about what she said previously.
Yes, what she informed the defendant of.
Okay. Response to that?
Your Honor, in the Midlands jurisdiction, a witness's own out-of-court statements are still considered hearsay, and therefore
Do you have an exception for that, Counselor?
Yes, Your Honor, I would say that this is not being used for the truth of the matter asserted. The truth of the statement is that Ms. Doolittle was conducting this audit. What we're using the statement to show is, if I may proffer, Ms. Doolittle will testify that in reaction to Ms. Doolittle telling the defendant about this, that the defendant turned pale and quickly went back to his room, and that is what we are using these statements to elicit. The plaintiff is not concerned with whether or not Ms. Doolittle was actually conducting this audit, just that the defendant learned about this.
Understood. I'm going to sustain the objection. Just because it's being used to show that the statement is true doesn't mean that it's not ultimately leading to the ultimate issue at play, which is whether or not Mr. Thompson committed this. So I'm going to sustain the objection.
Yes,
motion
Your
to
Honor.
strike offending testimony.
Yes. So stricken.
Yes, Your Honor. Now, Ms. Doolittle, I'd like to turn you to the third voice memo, 29C.
I'm there.
And if you could read aloud for the jury the first 4 sentences of this.
It's time, Kirby. After we hop off this train at the supply stop in the morning, remind me to swing by a lawyer. Taylor has crossed me for the last time. I just need to make sure I do this before I change my mind, or before Taylor changes it for me. As expected, Taylor wasn't all too happy with me when I told Taylor what I've been planning since February. Though, despite our argument, Taylor still gifted me some tea and a teacup.
Now, Ms. Doolittle, you just mentioned something about Bancroft planning something in February. Did Mr. Bancroft ever mention to you something that he had planned in February?
The only thing Avery really mentioned in February pertaining to Taylor was cutting Taylor off if Taylor crossed him one more time.
Objection, Your Honor, to hearsay to the statements of Avery Bancroft.
Yes, Your Honor, if I may respond.
Yes.
This is an exception to hearsay under Rule 803.3, then existing mental state or condition. Under this rule, any statement of a declarant's motive, intent, or plan is an exception to hearsay. In this case, the statement that Ms. Doolittle just offered from Mr. Bancroft was that he was going to cut the defendant out of his will if he crossed Mr. Bancroft one more time. That is Mr. Bancroft's intent, to cut the defendant out of his will if he crossed him one more time.
May I respond?
Yes.
Because this is contingent on something happening, this is not representative of Mr. Bancroft's plan or intent. It only would happen in a certain circumstance, and therefore is not a concrete plan.
May I respond?
Yes.
Yes, Your Honor. In the Rule 803.3, it doesn't say anything about whether or not a plan is contingent on anything. It is still Mr. Bancroft's intent to do an action based on something else that the defendant does. It's still his intent to either cut the defendant off if the defendant crosses him one more time, or to keep the defendant in his will if the defendant doesn't do anything. That is Mr. Bancroft's intent whether or not it is contingent on something happening has no bearing on whether or not it falls under the 8033 exception.
A brief response, Your Honor.
Not necessary, I'm gonna sustain the objection.
Yes, Your Honor.
I agree that if circumstances were to change, then he would change his plan, and I think that that is reflected, so I'm sustaining the objection, if you could move on.
Yes, Your Honor.
Motion to strike pending testimony.
So stricken.
Yes, Your Honor.
Now, Ms. Doolittle, what were you doing later that morning on April 25th?
April 25th, I finished my accounting audit around 4 a.m. and I wanted to bring it to Avery as soon as possible. So I went to his cabin and I knocked on the door.
Did Mr. Bancroft respond?
No, but I did hear a voice that sounded just like Taylor Hobson.
And what did this voice that sounded exactly like Taylor Hobson say?
Informed me to go away.
Objection, Your Honor, to authentication.
Okay, response?
Yes, Your Honor. Ms. Doolittle has testified that she is familiar with the defendant as she was an employee of Mr. Bancroft's for many years. She knew that the defendant was the child of Mr. Bancroft and that she had heard them arguing on the phone several times, and that they spoke on the train several times. This more than meets the preponderance of more likely than not of whether or not this voice was Taylor Hobson's.
May I respond to those grounds?
Yes.
The defense has it on a good faith basis that this was overheard as a whisper through a closed door. Additionally, there is no testimony on the record that this witness and Taylor Hobson spoke on the train, and therefore there has not been enough foundation laid as to how this witness could possibly identify the voice as Taylor Hobson.
I agree with that. I'll sustain it. Perhaps it might have been better in the speculation objection, but I do agree on those grounds. Yes.
Motion to strike a pending testimony.
So stricken.
Yes, Your Honor.
Ms. Doolittle, what did you do after you went to Mr. Bancroft's door?
After I went to Mr. Bancroft's door, I went back to my cabin and I went to sleep for about an hour. I really had a lot of trouble sleeping.
When did you wake up?
I woke up around 5 a.m. I went to Amy's cabin. You know, that was my normal morning routine. I'd go in there, bring his coffee. Instead, this time when I opened up the door, I found Avery lying on the floor. I checked his pulse, but it was weak and faint. I immediately called out for help, and before I knew it, Dr. Hillary Edmond ran in, started performing CPR. And then out of nowhere, she announced that Avery didn't make it.
I'm sorry for your loss, Ms. Doolittle. Are you still employed by Bancroft Estates?
Currently, no. Taylor became the interim CEO right after Avery passed, and called me into her office on the first day and fired me.
Did the defendant say anything else at this meeting?
Taylor told me that she didn't let Avery get in the way of her plans, she's not gonna let me either, and the only thing that her father's ever done for her good in life was die.
Thank you, Ms. Doolittle. I have no further questions at this time, but let the record reflect that I'm uncovering part of this demonstrative to reflect Ms. Doolittle's testimony that Avery Bancroft cut off Taylor Hobson after April of 2023. Would opposing counsel like me to keep this demonstrative up, or
You can be constructive, please.
Whenever you're ready, defense, you can inquire.
Yes, Your Honor. Good afternoon, Ms. Doolittle.
Good afternoon.
I'd like to start off by talking about something that you mentioned on direct examination. You mentioned these voice memos that Avery Bancroft had left you, right?
Yeah.
And you still have a copy of those?
I do.
Well, I'd like you to focus on 29B. Now, it says here, we can confirm, that Avery Bancroft said, "Though maybe I've been too harsh to Taylor, one of the other passengers confronted me today, and I shudder to think what might have happened if Taylor wasn't there with me." Did I read that correctly?
Yes, you did.
And this was at 7:55 p.m. on April 24th?
Yes, it was.
Thank you, Mr. Little. Now, mentioned that you heard a lot of arguments between Taylor Hobson and Avery Bancroft, correct?
Yes, it was like a week when it go by we were arguing on the phone.
And a lot of these arguments were about Avery Bancroft's will,
There were a lot of things, but Taylor would constantly argue with Avery about his will.
because Avery Bancroft was threatening to take Taylor out of the will, right?
Yes, Avery would constantly make threats towards Taylor about taking Taylor off. Taylor also would make comments about Sharon Shahee being in the will as well.
Right, like you just said, these threats were made to Taylor Hobson, right?
Yes, they were.
And these arguments continued on the train.
I assume so. I heard them only arguing once on the train though.
Well, I'd like to direct your attention to a note that was found in Avery Bancroft's cabinet following his passing. Let the record reflect, I'm constructing the demonstrative of the blown up Exhibit 37, which is pre-admitted for stipulation 6. Have you seen this note before?
I have.
And you don't have any idea what confession this could possibly be referring to.
No idea.
Thank you, Ms. Doolittle. Now, you are, however, familiar with a property of Avery Bancroft's that burned down, correct?
Yes, I am. The Black Bear Casino.
And you recognize an article about the Black Bear Casino fire?
I think I would if it was given to me.
Permission to approach the witness with what's been pre-admitted as Exhibit 21?
You may.
Would Your Honor like a copy?
Yes, please. Thank you.
Now, you recognize this article,
I do.
and it says, right at the top, the flames are long extinguished, but a year later, and the memory still burned red. Did I read that right?
That is what it says.
And it says right at the beginning here that 18 people died in this fire.
Yes.
And down at the bottom, it says that there was evidence that suggested Mr. Bancroft's involvement.
Yes.
But Mr. Bancroft was never arrested.
No, Avery was never found guilty or anything.
But you felt like he became public enemy number 1.
Yes, like this article shows, a lot of people did blame Avery for the fire, and thus Avery became public enemy number 1.
Well, I'd like to talk about someone else from Midlands that you saw on the train. You saw Kelly Dews at the welcome dinner, correct?
Yes, Kelly Dew is Taylor Hobson's partner.
And you wanted to say hi to her,
I did.
but she was glaring at Mr. Bancroft instead, correct?
Yeah, Kelly seemed very standoffish.
Right, and you did have the opportunity to talk to her later on the trip, correct?
Yes, me and Kelly did share a few exchanges throughout the trip.
Right, she asked you why on earth you would work for someone like Avery Bancroft. Isn't that correct?
Yes, that is what Kelly asked me.
And she followed up by saying, there is still time to be on the right side of history. Isn't that right?
Yeah, I have no
Objection
idea what
at
she
this
meant by
time
that.
to hearsay the statements of Kelly Dews in this question.
Can you repeat the question?
Kelly Dews followed up by saying, there is still time to be on the right side of history.
I agree with plaintiff's counsel. Here's that.
Can I offer case law to suggest that it's
Sure.
we are not using this for the truth of the matter. If I can direct your attention to moment of course let's see find the page. Thank you. Page 7, State v. BF Della Porta. This defines hearsay as a statement that meets a two-pronged test. It must A, assert a fact, and B, be offered to prove that assertion of fact. The assertion of fact in this statement is that there is time to be on the right side of history. We're not using it to assert that. We don't care whether there is or isn't time to be on the right side of history, and therefore this is admissible and not hearsay.
May I respond?
Yes.
Your Honor, per your previous rulings, this statement is being used to go towards the defense's ultimate contention, which is that Kelly Dews was the only person responsible for Mr. Bancroft's death. Using this statement directly goes, for the truth of its matter, goes to prove that Kelly Dews was in fact angry about Mr. Bancroft and plotting to kill him on the train, and that there was still time left before he died to be on the right side of history. Defense is certainly using this for the truth of the matter asserted, and it should be excluded as hearsay.
I'm gonna sustain the objection.
Yes, Your Honor.
Sure. But to be clear, Ms. Doolittle, in these conversations with Kelly Dews, she never had a single good thing to say about Avery Bancroft. Isn't that right?
No, we didn't really talk much about Avery, but yeah.
Thank you. No further questions, Your Honor. Let the record reflect on retrieving the exhibit from the witness.
Any redirect by Sunday?
No redirect necessary, Your Honor. I just ask that Ms. Doolittle be allowed to step down.
You may step down.
Let the record reflect on the deconstruction demonstrated as well.
So reflected.
Your Honor, at this time, if we may set up a prepared demonstrative.
You may.
Your Honor, just to tell the board that I might also be able to move to see the demonstrative. Yes.
Your Honor, the defense calls Dr. Hillary Edmonds to the stand.
Would it be at all possible, I see that there's gonna be more demolished than I assume, correct? Would it be possible to just use one instead of having to?
We're mental.
Okay, perfect. That way neither one of you has to continue to.
Perfect, thank you, Your Honor. May I proceed?
You may.
Please say your name for the court.
Hello, my name is Dr. Hillary Edmonds.
This might sound redundant, Dr. Edmond, but what do you do for a living?
While this may come as a surprise, I am a doctor, specifically a physician in pulmonary medicine. That just means diseases of the respiratory system. I'm currently based in Argentina as a medical consultant.
Why are you here today?
Well, I was on the Mid-Riverina Express in 2022 when Mr. Avery Bancroft unfortunately passed away. I was the one who was performing CPR on him and unfortunately did eventually have to call his time of death. So I was asked to prepare an expert report related to that case.
Okay, Dr. Edmond. And what's your educational background?
Well, I got my BS in biochemistry from Colorado College, my MD from the Stritch School of Medicine, and I then went on to complete my residency at the University of Alaska Hospitals.
Okay, I understand you created an expert report in today's case. Did you use any singular method to create this report?
Yes, I use what I like to call a combined chronological analysis, where I take all of the evidence I was provided in a case. In this case, that meant both my in-person interactions with Mr. Bancroft, as well as the evidence I was given afterward to conduct a full review of everything I was given and come to a conclusion regarding his death.
Okay, is this method considered reliable?
Yes, it's the standard method in my field and the one I use in all my peer-reviewed papers.
And did you reliably apply this method to your report?
Yes, I did.
Did you review any relevant documentation to help you create your report for today?
I did. I reviewed Mr. Bancroft's death certificate, his autopsy report, and his medical records.
Okay, I'd like to begin with Mr. Bancroft's medical record. Would you be familiar with that if it were showed to you?
Certainly.
Your Honor, let the record reflect I'm approaching opposing counsel and the witness in turn what has been previously marked and admitted as Exhibit 20. Would Your Honor like a courtesy copy?
Yes, please.
Your Honor, pursuant to Stipulation 6, this exhibit is pre-admitted.
Okay.
Dr. Edmond, how did this medical record help influence your report?
Well, this record told me that Mr. Bancroft was diagnosed with chronic kidney disease, stage 3, in October of 2021. Chronic kidney disease is one I've studied a lot in my work of internal medicine.
Did you deduce anything from the examination notes of this medical record?
Yes, these notes told me not only that he had CKD, but that he was taking a medication to keep his potassium levels low, and that there was someone else present with him at this meeting.
And who was that, Dr. Edmond?
It says Taylor Hobson.
Okay, and you're gonna have to help me out a little bit. What is chronic kidney disease?
Of course, chronic kidney disease, better known in the field as CKD, is one that occurs when someone is unable to filter out the toxins in their body, specifically when their bloodstream doesn't have the correct faculties to filter out toxins in the blood. Excuse me.
Thank you, Dr. Newman. You can set that aside. Now, regarding Mr. Bancroft, do you know how Mr. Bancroft might have ingested this potassium?
Yes, it's likely that Mr. Bancroft ingested a potassium-rich substance such as banana extract, causing him to experience hyperkalemia, which comes as a result of chronic kidney disease.
Well, why is having high potassium considered dangerous?
Well, for someone with CKD, hyperkalemia or high potassium can be fatal. It can cause cardiac arrest, and it could eventually lead to death.
Do you know if Mr. Bancroft had high potassium levels at his time of death?
Yes, Mr. Bancroft did. He had very high potassium levels, and for someone with CKD, anything higher than baseline is concerning.
Okay, Dr. Edmond, I'd like to move on to another document you reviewed, Mr. Bancroft's autopsy report. Would you be familiar with that?
I would.
Your Honor, let the record reflect I'm approaching opposing counsel and the witness in turn, what has been previously marked as Exhibit 19A. Would Your Honor person counsel?
Yes, please.
Your Honor, pursuant to stipulation 12, all objections have been waived to the entering of this exhibit.
Thank you.
Dr. Edmond, how did this autopsy report help you create your report for today?
This autopsy report told me not only some more details about Avery Bancroft's medical history and his time of death, but also specifically looking at the toxicology section of this report, I found out more about his hyperkalemia levels, specifically that there was a preliminary window when he could have ingested this potassium.
Okay, do you know why Mr. Bancroft might have had heightened potassium levels prior to his time of death?
Yes, this would have had to be from ingesting some sort of potassium-rich substance, such as banana extract, which I reviewed again as part of conducting my review of today's case.
Objection, Your Honor, at this point to 702. I believe the expert is making an improper expert opinion, if I may be heard.
Yes. I take particular issue with prong D, that the expert has reliably applied the principles and methods to the facts of today's case. Now, I have it on a good faith basis that this doctor has an extensive negative history with Mr. Bancroft, and that this witness would admit that treating Mr. Bancroft or making any conclusions about his conditions would otherwise warrant a recusal under normal circumstances. I'm happy to adhere on this matter, if permitted.
Your Honor, if I may respond.
You may.
Not only do I think a voir dire is unnecessary, I believe that it is completely irrelevant to today's case, especially because Dr. Edmond's past relationship with Mr. Bancroft had no impact on their treatment of him in today's case. They even performed CPR on him for 20 minutes prior to his time of death. If opposing counsel has any issue with Dr. Edmond's prior acquaintances with Mr. Bancroft, they're free to cross on it, but this in no way goes to their expert opinion, which is absolutely built on reliable facts and data.
If I may, Your Honor, briefly.
Yes.
While their facts and data may be reliable, their application is not. And that bias that they have with Mr. Bancroft, that this witness would admit under normal circumstances, such as creating their report or testifying in court today, would warrant a recusal. That witness will admit this on the stand if I'm allowed to voir dire. And because of this, this conclusion is inadmissible because they are unable to make any form of reliable application of their method to the facts.
Your Honor, if I may respond.
Yes.
Your Honor, if a witness were to be recused because of their past experiences with the decedent, then that would have happened before trial. But here, Dr. Edmond sits within full capability of being able to testify to their facts and their expertise that they have collected for today's case. Again, if opposing counsel has issue with Dr. Edmond's past history, they can take it up on cross, but it has no influence on their expert testimony, especially regarding the time of death or the impact of death that was for Mr. Bancroft.
Brief final response, Your Honor.
Briefly.
A recusal from this case would require the doctor to recuse themselves. In this case, the doctor is testifying voluntarily. I believe a voir dire would expose these biases and the impact that it has on their ability to reliably apply the method to the facts in today's case. So again, I would ask the voir dire in this matter to prove that the doctor is unable to do so reliably today.
I'm going to deny the objection and overrule it. Voir dire typically would be to question the expert on their expertise as an expert. I think that your objection is more towards bias, which can be addressed during cross. You are more than welcome to address any of those biases during your cross, but I think that any voir dire concerning specifically their capacity to be an expert, given the fact that they've, been a doctor and they've looked at these medical reviews since, looks from 2022, there's nothing showing that they have failed in their capacity to be an expert in that regard. So I'm going to overrule it, but feel free to go into whatever bias you think is necessary during your cross.
Yes, Your Honor.
Yes, sir. Where were we, Dr. Edmond? I just asked you about this autopsy report. What did you find from it again? Oh, sorry, apologies. You reviewed banana extract in today's case?
Right, I was just saying that because this toxicology report was talking about high potassium levels found in Mr. Bancroft, something like banana extract could have been significant in his cause.
Would you be familiar with that banana extract if I were to show it to you today?
Certainly.
Your Honor, let the record reflect I'm approaching opposing counsel, and the witness in turn was been previously marked as Exhibit 40A. Your Honor, this will be published to the jury if it is entered into evidence. Now, Dr. Edmond, what is this?
This is the bottle with the label of banana extract that I reviewed in relation to today's case. I was given the label.
Is it a fair and accurate copy?
Yes, it appears to be.
And it hasn't been changed or altered in any way?
Not that I can tell.
Your Honor, the plaintiff offers Exhibit 40A into evidence.
Any objections?
Pursuant to stipulation 10, this is a commercially sold product, so pursuant to case law, no objection, Your Honor.
Perfect, it is so admitted.
Dr. Edmond, did you come to any conclusions regarding that bottle of banana extract?
Yes, I concluded that this banana extract would have had more than enough potassium to trigger Mr. Bancroft's hyperkalemia to cause him to have high potassium levels and unfortunately experience cardiac arrest.
And are you personally familiar with that bottle?
I have seen this full bottle before, something that looked exactly like it in a store on the Mid-Riverina Express.
And who was holding that bottle?
It was Taylor Hobson. She was, or he was looking at all the bottles in the store, picked up this one and looked at it for quite a while.
Okay, Dr. Edmond, I can take that from you. Your Honor, permission to publish to the jury?
You may.
Dr. Edmond, do you know how Mr. Bancroft, when Mr. Bancroft might have ingested this potassium?
Yes, I actually prepared a timeline before coming to court today in order to help better understand when he might have ingested potassium.
Your Honor, permission for my witness to make use of the prepared demonstrative?
Yes.
Dr. Edmond, can you tell us a little bit about this timeline?
Yes, this is the timeline I prepared, and I worked backwards from his time of death, 5:42, in order to find out when the most likely window of potassium ingestion was.
Okay, Dr. Edmond, since you worked backwards to find a point of ingestion, let's work backwards on this timeline. What specifically is 5 a.m.? What does that have to do with it?
5 a.m. is when Mr. Bancroft started experiencing the onset of his hyperkalemia, again, high potassium symptoms.
Why is it important to know when Mr. Bancroft first started experiencing symptoms?
Well, when someone with chronic kidney disease is experiencing hyperkalemia, the onset of these symptoms are usually 90 to 120 minutes post when they've ingested the potassium. Because I knew about this time frame and had the time of his onset, I was able to find then the window of ingestion.
Your Honor, let the record reflect I am removing this covering, which underneath states that 3 to 3:30 a.m. is the most likely window of potassium ingestion. Thank you, Dr. Edmond. You can take your seat.
To 403, misleading the jury, may I be heard?
Yes, you may.
I believe what opposing counsel just uncovered, that the most likely window of ingestion was 3 to 3:30 a.m., goes to mislead the jury. While that may be this one expert's personal opinion, what we have entered into evidence that has been agreed upon by both sides prior to trial and confirmed by an independent medical expert is that the time of ingestion is between 2 and 4:30 a.m. While I don't believe that the entire testimony of the expert is misleading, I do believe putting it on a demonstrative in this fashion does lead to does go to mislead the jury.
Your Honor, may I respond?
You may.
If I'm going to specifically read right after, potassium ingestion is between 2 a.m. to 4:30 a.m., though that window may be narrowed with further calculations. This is exactly what Dr. Edmond has just done for us today, and it is through reliable principles that they have given us this time frame of 3 to 3:30 a.m. Furthermore, the bar for something to be substantially more misleading than it is probative is very high in the state of Midlands. And this is far more probative than it is misleading to the jury, because this is a factual expert opinion that this witness has just laid onto the record.
If I may, Your Honor.
You may.
I'm not denying that the window can definitely be narrowed by an expert with knowledge, and that can be this expert's personal opinion. But I believe the manner in which they have presented this evidence, being on a demonstrative presented to the jury, that the time is between 3 and 3:30 a.m., is misleading, considering independent medical experts and consultants. The only piece of evidence that both sides have agreed on prior to trial states that the definite window is 2 to 4:30 a.m. I believe that's misleading, Your Honor.
Your Honor, if I may respond.
Briefly, that would be the end of that.
Yes, Your Honor. Both opposing counsel and I do not need to agree on when exactly the window of ingestion is for it to be admissible to the jury. Specifically regarding this, there is no misleading characteristic about it. We have been very upfront with the jury, saying that this is the most likely window of potassium ingestion as determined by Dr. Edmond, and it is not misleading in any way. We're not saying this is definitively the window of potassium ingestion. We are saying this is the most likely window of ingestion that Dr. Edmond has deduced through their calculations.
Okay. I'm going to sustain the objection. I think that it is extremely prejudicial for the jury, because this is a expert telling them that this is when it is that this occurred, and we have opposite testimony based off of what you just presented. So I think that I agree with you that this is more likely to prejudice the jury than be anything probative. So I do ask that it be covered then while it's in the jury's presence.
Yes, Your Honor. Now, finally, Dr. Edmond, what were your final conclusions regarding the circumstances surrounding Mr. Bancroft's death?
Well, I came to the conclusion that Mr. Bancroft experienced hyperkalemia due to his chronic kidney disease on the early morning of April 25th, 2022. He experienced cardiac arrest because of this and unfortunately passed away. It's likely that he ingested a potassium substance